Yeah, that's right. It's Thursday, Thor's Day. Get your hammers for warfare out and let's go out and raise a little hell today, shall we? I'm on a train soon, heading down to D.C., where I've got another January 6th sentencing in the swamp tomorrow. And then I'll beat a hasty retreat back to New England, hopefully on a midday train, and be back safe and sound in New Haven in the middle of the day. Wait a minute. Safe, sound, New Haven? I don't know about that. I'll be back anyhow. So, interesting result. Welcome back, Mike. We missed you yesterday.
Yeah.
People in the comment section, we had hardly anybody viewing. People were saying, "Where's Mike? Mike up?" Set Mike free. Down with Norm. Norm sucks. And then I realized they were all coming from my ex-wife. So thank you for listening, dear. As you know, I've got nothing to say, but I say it oh so well. So interesting poll results last night. Apparently, and let's talk about it for a moment. Biden is ahead in the polls by as many as 4, maybe 6 points, depending on how you read the polls. And when and this is in the head-to-head race of Biden versus Trump, the large it's a close race, not too close to call, but Biden has pulled ahead. It was statistically almost even the last time poll results were reported, I think, in December. What's changed? Women. The women's vote is going toward Biden, as are the votes of independents. I don't know what to make of the poll results. I don't know if the poll
I
results.
personally don't believe that Biden is having more sex than Trump. I don't think that's right.
Oh, yeah. I mean, that's a thought. Joe Biden sex. Somebody leads him into the room. He kind of wanders up to the woman. Hi, my name's Joe. Some act is performed. He wanders off stage, and she's thinking, man, what did I get myself into? But it's either that or the Donald. I mean, I'm wondering about the poll's results, and I'm wondering about the E. Jean Carroll effect, because if that poll was taken in the same week that the E. Jean Carroll verdict was reported, you would expect a certain amount of female triumphalism. I mean, after all, there Jean Carroll was with her lawyer on MSNBC crowing about what she was going to do with all that money. In another interview, she talked about how she was going to donate it to things that Trump hated. I'm told, or I've read, that she even appeared on The View, and the good women of The View were beside themselves with joy. Here's a question, though. Did Donald Trump really have sex with that scarecrow? This is a misogyny alert. Women, you might want to find something else to do. There's a saying that men have, that they wouldn't, quote unquote, do someone with someone else's member. And I could may be blunt about it, but there may be children listening. I mean, would Donald Trump do E. Jean Carroll with a broomstick? I realize that even the Scarecrow in The Wizard of Oz probably has sex, but E. Jean Carroll? Okay, so he did. So he defamed her. $83 million, and then people are high-fiving as though this is a salvation of the republic. There's just something unseemly about it, and I can't tell whether it's my own misogynistic instincts that makes this difficult for me, or what the point I'm missing is. But I can't help wonder about the E. Jean Carroll effect on the poll last week. And I suspect that women will vote more for Biden than they will for Trump. But I just don't know.
Maybe not. But here's the thing: we haven't sexless in the city. That's hilarious, Maury. What we don't have yet is a VP nod, and my expectation with Trump is that he is going to shore up any perceived weaknesses in the voting demographics based on his selection of vice presidential pick. Many people, the same poll showed that Haley would be the better candidate in a general election.
A closer election, right?
But that's been the narrative for the past couple of weeks, and we know that the establishment's chosen candidate is definitely Nikki Haley, right? That's where all the support is going. So on the one hand, it's my opinion that you take this poll with a grain of salt. On the other hand, it's not out of this world to believe that suburban women of a certain type and variety gravitate away from Trump, not necessarily toward Biden, but away from Trump. And
women who shop at Talbot vote Biden. Talbot's vote Biden's.
And to that end, it appears as though this is a pretty simple mop-up operation for Trump's team in terms of who and when they announce a vice presidential pick for his ticket.
Is there a universe in which you see him picking Trump, that is, Nikki Haley?
I mean, the thought has crossed my mind. I just it may be that that is perhaps a strategic maneuver to keep her out of anywhere out of Congress and off of, off of the mainstream stuff, but also garner that voting base since it is so strong. There's also been talk of, her name is escaping me right now, forgive me, but the, former Democrat, former military veteran, Hawaii, representative. What's her name?
Yeah, I know who you're talking. It's not working for me either. I
Right.
don't think Elise Stefanik does it. I hear some discussion of Robert Kennedy. I'm not sure where he'd do. I even saw Alex Jones' name pop up in discussions the other day, and surely, folks.
Julian Julian asked a great question because I was trying to figure out the best way to introduce this. So my understanding, Norm, from reading is that the E. Jean Carroll's lawyer was at the judge's law firm, and that the judge in the E. Jean Carroll Trump case actually presided over that lawyer's co-counsel's wedding, and there was no disclosure of either of those facts prior to
So,
the.
as to the first, the mentorship relationship at the firm, I was less troubled by that than many, certainly by the author of the article in the Post. My understanding is that this was a large white shoe firm. I think it might have been Paul Weiss. He was a managing partner. She came in as a young, I think it's a she, as a young, yeah, Roberta. She came in as a young lawyer, and he was a mentor to many in the firm.
Tulsi Gabbard. Sorry. Thank you, T girl, as always. T girl. I love
She left the firm. Thank you, T girl. She left the firm years ago, and he did not have an ongoing relationship with her in the course of her career. If all of that is true, I'm not troubled by it. For example, I have a former associate of mine who I hired many years ago who just became an appellate court judge here in Connecticut, and among the questions she was asked is, whether her relationship with me would have any bearing on how she decided cases. She's decided to recuse herself from my cases to avoid the appearance of a conflict. But candidly, I mean, she worked for my firm 25 years ago. I doubt and we've remained friendly since. I doubt very seriously that relationship would affect her judgment on the bench. But the appearance of impropriety always matters, and it would have been better for Kaplan to put something on the record. This second thing about presiding over a partner's wedding, suggests social relationships again that might have been better off disclosed. I'm not so sure that these are disqualifying events. It would have been wiser to put things on the record.
May I
So
ask a question
parties,
here, Norm? Was there ever a time, and I'm sorry to interrupt, I think I'm getting at where you're going, but I'm a younger lawyer, right? Certainly early in my career arc for being a practitioner, but was there ever a time in your career where such relationships would have been disclosed? Was it customary that these sorts of relationships would have been disclosed to the court? And are we perhaps in an era now that has departed from some of those civic norms within the practice of law, or is this kind of adding smoke where there's no fire? And I'm asking that earnestly because we always refer, I think, affectionately to the past, and we need to get back to our roots and get back to basics. And this isn't how it used to be. But is that even true in this case, in your practice experience?
Again, my experience is different than that of a New York lawyer. This is Connecticut. It's a very small state. I think we've got like 3.5 million for the whole state. That's less than metropolitan New York. And so within the bar, most of us know one another and have had something to do with one another, and relationships cross-cut roles. I once appeared before a hearing officer. She did such a great job in an administrative agency. I offered her a job. She worked for us. She became independent. She became a trial judge. Now she's an appellate court judge. I represented a family member of hers when she was in a jam. This game of sort of hot potato is common in a small state, and I don't think it affects the quality of justice administered. I think the better practice is to disclose relationships, but I'm not sure that has deteriorated over time. As I read the New York Post story, and I did read it on Kaplan's relationship with the judge, Roberta Kaplan, and by the way, that's just the same name, no relation. I just was unmoved by it. I thought, yeah, well, that's what you'd expect. It's a big firm. He was a mentor to the firm. I'm not aware of any ongoing or special relationship there. I think the failure to disclose it gives people something to talk about and is delegitimizing, to use our favorite word. And so the better practice would be to put potential conflicts on the record, let parties decide whether they were an issue. Those relationships are an issue. If they are an issue, let the parties raise them and then let the court decide something. So I think, Julian, the better course would have been to disclose. Mike, I'm not aware that professional ethics have changed as life has become snarkier, and I think it has, given social media. One would have expected better disclosure rules to avoid this sort of embarrassment.
Well, I
And
think well, established norms matter, and I think that that's why you were referencing, the your Connecticut bar, the sort of the local nature of that, the smallness of that, and the intimacy that you enjoy with, at least from a professional and sort of a collegial capacity with those other attorneys and judges and stuff like that. And then, Manhattan is its own beast from that perspective. I can appreciate that, but I think that on the whole, there appears, at least in my mind's eye, I envision a time when the practice of law was much more analog, and therefore there was a heightened expectation of disclosure of these things because they weren't so easily come about in
yeah,
sort of reporting and stuff like that. And I don't know, maybe this is more interesting to me than it is to you or to the audience. So I don't want to beat a dead horse here, but it does seem
kick
interesting
me, I'm dying.
maybe we can just quickly transition to the New York Times case, right? As another example of sort of these issues when we have a common party that is Trump, right? It's almost as if he is a sort of a lightning rod for us to see these various issues play out because he has a common set of interests, and all of these interests are intersecting with the legal system in so many different ways. It's phenomenal, to be frank with you, that we have an opportunity to see the legal system apply itself in so many various ways to a single person, right?
So Donald Trump might be sweet generous. I mean, in other words, a class of his own, a case unto himself. But he certainly does draw out the legal issues. And so yesterday, a judge ordered Donald Trump to pay almost $400,000 to lawyers for the New York Times and several journalists working for the Times. And this is by way. Trump had sued the Times for defamation, for its reporting on his financial empire and the suggestion that it was a house of sand or house of cards built on sand. And the Times responded by saying, we're doing our job. We didn't defame you. We reported. And even if we were wrong, we have a reportorial privilege. And the Times filed, I believe, what's called an anti-slap motion to dismiss against Trump. And I do want to unpack that. A SLAP suit, SLAPP, is what's called a strategic lawsuit against public participation. And historically, they have been used by large companies to silence critics. You don't like the way your Nike shoes fit, just do it. Nah, not in Nike, and then you get a lawsuit from Nike, and it's like, oh my God, now I've got to defend this. I've got to get a lawyer. It's going to cost me tens of thousands of dollars even to defend successfully. The company, by suing, says we'll withdraw the suit if you withdraw your claim, and they've won, but they've silenced the market. They've chilled it. This was a strategic lawsuit against public participation in the debate of issues of concern to consumers. Not long ago, 10, 15, maybe 20 years ago, states began, and I think 33 or 34 states now have this legislation, to have anti-slap legislation designed to protect journalists and designed to protect those who speak on matters of public concern. It's a cost shifting device, a fee shifting device that permits a journalistic entity to argue to the court that there's no probable cause, no reason to believe that this case will succeed, and therefore it should end now, so as not to burden our speech rights. And what's more, it should end now with the plaintiff, the person bringing the action, paying our legal fees. And here's the significance of that. American civil litigation generally operates under the so-called American rule. That is, losers bear their own cost. You can sue someone, and if you sue, unless a statute has a fee-shifting device in it, oh well, that's the money that you've invested. That you brought the litigation, you lost. The winner has the satisfaction of winning, but the disability of paying legal fees. And so legislators sometimes enact fee shifting statutes that say the loser should bear the winner's costs, because there should be a stake in the game. You shouldn't be able to view litigation as a form of lotto where the well-heeled, the wealthy, can just throw their money out, and if they lose it, they've lost nothing, thus crippling those who are less well-heeled.
That's
And
right.
so,
So, Norm, question for you, because Mark Randazza is a major proponent of anti-SLAPP legislation to be had in all 50 states, and he's made me aware that North Carolina doesn't have anti-SLAPP legislation and seeks pretty desperately to change that at some point in his career. But my question is, what is it about the existing, I guess, civil procedure framework in those states that lack an anti-SLAPP statute that provides an equitable remedy similar to that of an anti-SLAPP? So I'm thinking a motion for summary judgment, or even a 12b6 motion, right? Are those adequate, and if they're not, why are they not adequate or on the same level of an anti-SLAPP legislation in terms of the fee shifting?
so the so again, think about the financial incentives that parties bring to litigation. If
Sure.
you've got $1 billion in the bank, spending $1 million on legal fees to torture one of your adversaries, even if you lose, is no big deal. If they have to spend in kind or even half of what you spent, they spend $500,000-600,000 to win a lawsuit that you brought. Your lawsuit isn't frivolous. You can't be sanctioned for filing a frivolous lawsuit because your claims were prima facie valid. You didn't violate the rules of court, so there'll be no Rule 11 sanctions. And so basically, the wealthy get off with impunity and tie up those who are simply doing their job. And so, in a SLAPP context, there's what's called a special motion to dismiss, where the parties can immediately bring to the court's attention the infirmities of the plaintiff's case. In other words, to say there is no case there, rather than waiting until summary judgment. So for you non-lawyers, what are Mike and I talking about? In a civil lawsuit or in a civil context, a person who wants to bring an action must bring a complaint. And a complaint is a set of lists a set of facts and posits legal theories under which those facts, if true, would entitle them to relief together with a claim for damages. There are two types of pleading regimes in the United States. There is what's called fact pleading regimes and notice pleading. Federal court is a notice pleading regime where in almost every case you just have to give a short and plain statement of the nature of your claim and the basis for relief. Fact pleading states require a lot more information. So once you've filed that complaint, your adversary has to answer or respond. They can respond with a motion to dismiss saying it wasn't served. There's no personal jurisdiction. Saying you've failed to state a claim. That's 12b6. I often joke, if I were sued for being ugly, plenty of people would agree that's a valid claim, but the court doesn't recognize ugliness as tortious, and therefore I could file a lawsuit against you on a 12b6 claim to dismiss it for failure to state a claim. If you do state a claim, the other side then has to answer, and the answer would be to admit or deny the facts that have been alleged against you. Then you move into discovery, and in the course of discovery, both sides get to learn about the other's position and the information that they have in support of their points of view. The defendant may, for example, raise affirmative defenses, claims of his own, but they may even bring counterclaims, counter suits, as it were, against the plaintiff. Discovery permits the clients to learn about one another's position. And when discovery is concluded, a party can say, there's really no dispute here about the important facts, about the material facts. And so they can place before the court a statement of material facts not in dispute and say, because of this, I'm entitled to judgment as a matter of law. There was no contract. Nothing in the evidence produces it. Although the complaint validly laid out a contract claim, when we sought to discover the basis for that claim, we discovered there was nothing there. That's the traditional framework. So you go from complaint.
And very expensive, by the way. So what we
Yeah.
didn't say anything is written discovery, and discovery is extraordinarily cost prohibitive for the average person to indulge it competently and comprehensively. So this is really the basis for the anti-SLAPP.
So we go through the complaint, the motions to dismiss, the answer, summary, discovery, summary judgment, and then if there's a dispute about facts that matter, such that if a jury decides in one way, one side wins, the other way, the other side wins, then there's a trial. That's the normal course in civil litigation. The anti-SLAPP regime pushes everything to the front and requires, in some cases, expedited discovery, so that there can be an effort to dismiss a lawsuit immediately. And as an additional inducement and protection for defendants who are sued for exercising their free speech rights, there's a cost shifting component. And so, if a party is sued, as the New York Times was in the Trump case, and they win that special motion to dismiss, they can ask the court to assign attorney's fees to the plaintiffs and require the loser, in this case Donald Trump, to pay their costs. Now, take a look at the headline here. That's almost $400,000 in legal fees for the preliminary phase of the litigation. Part of that's just Manhattan talking. I mean, many years ago, I settled a lawsuit for somebody who was fired from a hedge fund that was later the subject of a congressional inquiry, and he was paid money when he left, and Congress and the SEC thought it might have been hush money, and I brokered the payment of the settlement. So I find myself on the receiving end of an SEC FBI investigation. I go down to New York with my own lawyers to sit in a prosecutor's conference room where I'm asked questions about it. And I say, look, I realize, and I made a lot of money in the transaction, maybe $250,000. And, I said to the FBI, I realize it's a lot of money. He says, no, this is Manhattan talking. You should see what the other people are making. And I'm thinking, wow, I need a Manhattan law license. So I quickly entered the Southern and Eastern District of New York's federal bars. But the point is, these are eye-popping legal fees. And now Donald's going to have to pay them. And I'm a little put off by that. I mean, I think the New York Times probably padded its legal fees. I would be sort of scratching my head wondering what in a preliminary proceeding could cost $400,000. Anything north of 100,000 would have me wondering what's up. But anyhow, anti-SLAPP litigation, you should be aware of it. That's what happened here. The American rule: loser paying their own cost. That's the law. And now you learned a little bit of it. Thanks
Jackson
a
Barrett
lot.
asked another question just to tease out another proposition here. And I get the joke, Jackson. He asks, are not all facts in dispute in a postmodern world? Define a woman, ... That may be the case, and we can admit that, sure, in a broken grievance studies inspired world, that all facts are in dispute and nothing matters. However, the standard for summary judgment, or a 12b6, is that the moving party, that party that is trying to dismiss the lawsuit, tells the court to look at everything the other side claimed and says, even taking all of the facts in the light most favorable to them, right, the way that they positioned it, there is no dispute as to a material fact, and we're entitled to judgment as a matter of law, right? That's the truth.
Only, yeah, and Jackson, I take your humorous point now. I'll take my tongue out of my cheek, and only and say the following: in no serious piece of litigation would the proposition "I can't tell what a woman is" be accepted at face value. The only place that kind of swill passes muster is when you happen to be a preferred candidate for Supreme Court Justice of the United States.
There it is.
I wonder why that is. Hey, what's going on in NIL world, Mike? I saw this story this morning and I thought, man, Mike must be up early revved up on this one.
Yeah, well, I wasn't, but I am now. And, I feel talking about my feelings here. Thank you for being my shepherd here, Norm, as I talk about my feelings. It's always great to bring the
Chick alert. We're going to talk about feelings.
I just feel like the NCAA. Anyway, the NCAA has been sued under the Sherman Act, that is in violation of antitrust, by the Attorney General of the state of Tennessee, as well as the state Attorney General for Virginia. And the basis for that antitrust litigation is premised on the most recent proposals made by the NCAA, which would limit, and this is the narrow issue, which would limit a school's capacity to or a student athlete's capacity, a current student or a new student, so a high school student making the jump into college. So transfer portal read transfer portal or high school athlete going to college, it would limit their ability to collect on any sort of NIL compensation, that is name, image, and likeness compensation, only after they have enrolled in a given institution, Norm. That is the narrow issue. So this proposal by the NCAA is yet again shifting the landscape of how athletes are allowed to be compensated in the controls and mechanisms. And apparently this has kind of been the death knell for the NCAA. They might actually just disintegrate after this lawsuit.
Yeah, so, confession to make, I don't understand the mechanics, the nuts and bolts of antitrust law. But there is a claim that somehow the NCAA has stepped in it this time. That they are engaged in control of a competitive marketplace in such a way that it becomes anti-competitive. Is there really a chance that the NCAA is going to get whacked on antitrust grounds?
No, because and you can see there in the lawsuit that I've got on the screen, the antitrust, well, they might. Within this lawsuit, they might. But in terms of there being an active monopoly on college athletics, it was the NCAA v. Alston decision that allowed and authorized the compensation via NIL to student athletes that sort of broke that market structure into more than one piece, such that
Mhm.
the NCAA could avoid the scrutiny of having an unearned or an unlawful monopoly as it's read under the Sherman Act, right? But now the NCAA has come back around and is seeking to implement its control, almost a la the SEC, over the financial markets. The NCAA is sort of de facto starting to define how athletes can get paid, how institutions must go about sort of, I guess, scrutinizing these deals with student athletes, what they can do on the recruiting trail with respect to NIL and all of that kind of stuff. So
Let
what's
me
going
ask a really stupid question. I mean, and this is going to reflect the extent of my ignorance. And by the way, folks, it's not a crime to be ignorant. It is a crime to be willfully stupid. Willful stupidity means not asking questions that reflect your ignorance. Why are colleges obliged to be members of the NCAA? Why don't they just say screw
I
you?
I feel like I've been saying this for quite some time, right?
Oh,
That
maybe I'm only hearing you now for the first time. Bad, my
well,
bad.
it's sort of it's sort of a they're not obliged. However, the access to the championships and the marketing dollars and the revenue shares from conference titles, national titles, any sort of they are sort of the entity that they are the massive underwriter for national college athletics, right?
So
The
if you want to
NCAA.
play on the playing field that comes with
Correct.
the ching, you got to sign the thing.
Correct. And that's where the antitrust scrutiny emanates from, right? It is that the NCAA has massive market dominance, whether it's earned or unearned. They have a presence such that they control access to the broader market for monetizing college athletics, right? And until heretofore, that has been premised on the NCAA's tie to student athletes, right? And the fact that these are students of universities that fit within that collegiate system. My position for years, and I was criticized by some of my best friends, some of the people I'm closest to in the world.
You have
Uh,
friends?
yeah, a couple, one and a half. One of
Oh, the
the
things
half,
you learn on Law and Legitimacy every
and the
Monday.
half is in the basement. But the the criticism came from my position that at a certain point I recognized that the system was broken, and that if it was so important for people, the culture wanted college athletes to share in the compensation, the massive compensation and revenue being generated from the monetization of college athletics, that there should be no presupposition that the players playing on behalf of these institutions, these colleges, should have to be a student at that institution. In other words, I've been proposing a minor league system for probably a decade now, because it was my recognition that the integrity of education has completely gone under, right? The integrity of a college education is no longer in line with the value that one has to pay or go into debt to receive it, right? However, the peak of college athletics is in controversy with that, right? It has
Mm.
never been a more valuable spot to be than on a college campus in the American South, playing in the SEC on Saturdays, right? On the football team, right? It's never been more valuable than right now. For those two reasons, it was my position that it should be broken in half, right? That those two things should maybe have an arm's length relationship, but there shouldn't be preferred admission for college athletes, right? They should just be athletes on a payroll somewhere. And if they also wanted to be extended in education, that they have to make an application for the educational component, the same as any other student would have to do. That's been my
Yeah,
position.
it's a good. It's a
Because
good
nobody
argument.
cared to look at it from that perspective, or because the money was so tied up in all of that, and the boosters were like, "No, why would we ever do that?" Right? That would ruin the integrity of the whatever. We have this. We have this bastardization of the underwriting function that is the NCAA, and it is completely incapable of regulating a competitive marketplace because now we're watching all of the student athletes coming in looking to monetize themselves because they have independent social networks and value behind them, right? The 5-star, the 4-star, the blue chip prospects for these institutions, they are able to bring with them a potential for monetization based on their own social media followings, their Instagrams, their TikToks, whatever they're doing, the highlight reels that they're putting together and circulating on their own web pages, right? They have this inherent value. They don't need the value of the institution to necessarily, they just need the institution to get the out of the way, right? But the NCAA wants to create parity in the marketplace, right? Because your product is built on parity, competition, this notion that you're not always going to have an Alabama versus, I don't know, choose your tier
Michigan versus everyone. I think that's what you were trying to say.
there for this, right? But the idea, and that's what the NFL and the NBA do incredibly well, right? Perhaps you've got the Boston Celtics and the Lakers that will always do well, the Niners or the Patriots or whatever on a given season. But the idea of a product that is entertainment in competitive sports is that there is parity on the field, that the fan feels as though its team on any given Sunday may achieve victory, right? That's what drives the value. The NCAA has largely lost control over how to manipulate and create parity within the marketplace, right? Based on NIL. But NIL is just a symptom of a brokenness that existed far, far before that. So I hope that the state's attorneys generals in Tennessee and Virginia don't let this go and don't settle this out. I want them to go all the way. And I'd like to see, Attorney General Josh Stein, who's a feckless moron running for governor here in North Carolina. I'd like to see him put some weight behind this as well. And the
How
other,
can a feckless moron put weight behind anything?
well, he has an office, right? The same way that Biden is able to say that the administration is doing whatever the hell it's doing. Anyway, I'll get off my soapbox. But
No, I mean it's an important story. I guess I just I give you thank you for your drawing attention to it. I don't fully understand it. I just have a hard time imagining college sports without the NCAA. Then maybe that'd be a good thing. I don't know.
Pete Atkinson has a comment here for us. My workplace has had a March Madness bracket for the past couple of years, and the person who's won the bracket has consistently left the company or been fired within a year. We call it March Madness, and then the rest of your comment is cut off. But that's pretty funny.
Yeah, that is pretty funny. A little bit of anti-competitive pressure there. Well, listen, folks, we've talked our way through another 33 minutes of your life, and we're grateful that you listened to us. I'm grateful for Mike and shedding light on this NCAA stuff. We'll be back tomorrow. I'll be reporting from the swamp, and Mike will be wherever Mike is. But we hope you'll join us. Mike, how do people find us?
lawandlegitimacy.com, lawpoddaily.com. Find us on YouTube, Rumble, and X at lawpoddaily, Law and Legitimacy. You'll find us there. Apple Podcast, Spotify, Google Play, Overcast, Audible, wherever you find premium podcasts. My question for the viewers is, who have you recommended Law and Legitimacy to today? That's just the question. Norm, I'll see you tomorrow.
Ciao. Be well.